This show furnished by Karl Gerber and Employment Lawyers Group.
I fired back, but by and large, you bought yourself a lawsuit for
Talk Radio 790 KABC. This is the Karl Gerber Workplace Lawyer Show. I'm Karl Gerber, and I'm a real workplace lawyer. If you're a diehard KABC listener, you've probably heard me on Sunday nights from 7 to 8. When there's not going to be a USC game, and it's not going to eat into this time, I'm going to be on now Saturdays from 7 to 8. So I want to give you a little bit of background information. I represent employees. I'm a member of the California State Bar, the Texas State Bar, the Massachusetts State Bar, and the Washington, D.C. State Bar. I've been licensed in California since 1993. I'm referred to as one of the original employment lawyers, if you can believe that. I was the only one in the phone book in Los Angeles and the San Fernando Valley when I started doing employment law. I'm also a Los Angeles historian, and you're going to hear about Los Angeles in this show. I know a lot about it, and it comes into this script. If you were living in L.A. in the 50s, 60s, 70s, or 80s, you're going to like this show. You're going to find out I have a long career writing, lots of legal articles, but I do comedy too, and I do fiction. And a lot of the shows you hear, if you heard the Sunday night shows, well, hey, that's the most cutting edge, edgy, outrageous sketch comedy on commercial radio, and you're going to maybe get a little treat of that tonight. But we broadcast this show live from downtown, trendy Culver City here, and that makes it a little harder. So I've been on KABC since 2018 in April. This is actually episode 75 of my show. It's kind of exciting. The show's moving into other cities, and it's real big on the internet, about 20 different sound sharing sites. Of course, the Karl Gerber with a K channel on YouTube. So we want to kind of break into this time slot, and we want to give you some real legal stuff, because this week you might have heard about AB 5. A lot of employers have been calling up and saying, what is it? Well, Governor Newsom actually signed this into law this week, and it's about the gig economy. And it stops people in the gig economy from being misclassified as independent contractors. If you have questions about whether you've been misclassified as an independent contractor, you should give me a call at the office during normal business hours at 877-525-0700. If you've been misclassified as an independent contractor, weren't even paid minimum wage for it, 877-525-0700. Once again, 877-525-0700. So we're going to give you some insight on this new law in the first segment of the show. Then we're going to give you a real live example of a gig economy worker, if you can believe that, live in studio. I've got with me tonight Ann Guleser, who's one of the lawyers who works with me at the Employment Lawyers Group. She's worked for me since 2006. Ann, why don't you say hi?
Hi, Karl.
How long have you been practicing, Ann?
Since 2000.
Oh, wow. And you don't do anything but employment law either, do you?
No, it's just employment law.
And we're supposed to be talking about AB 5, which is now California Labor Code Section 2750.3. And it applies to a lot of people, but not everyone who's an employee. Can you tell us about who this new law that is going to make those Uber and Lyft drivers employees and other people like that? Can you tell us what kind of professions are now subject to this new law, which is really affecting the California workplace and is going to affect the valuations of a lot of these gig economy companies?
Well, Assembly Bill number 5 only applies to the gig workers. It doesn't apply to other employment. The bill lists the occupations it doesn't apply to. For instance, it doesn't apply to professional workers such as physicians, psychologists, lawyers, architects, accountants. It doesn't apply to professions like stockbrokers, veterinarians, direct sellers, real estate agents.
So far, all those people you're listing have licenses. They have professional licenses. Is that one of the reasons why this law isn't going to apply to them?
That's correct. It also doesn't apply to professional service contracts where they have their own business licenses and their own business locations. They can set their own hours, can negotiate rates.
So That's an important point I think the listeners need to understand. If someone really has a business, they have a business license, they're professionally licensed through the state bar or whatever it is, or real estate, those kind of people aren't all of a sudden going to be called employees because they have a real business. And this law is because of the Dynamex case, which is something I talked about very early on in the show. And we had a real live example of somebody affected by Dynamex, and she turned out not to be a normal operator. She was a phone sex operator. If you can believe that, being misclassified as an independent contractor. And so one of the things this new law does is it codifies what the Dynamex case said. So, Anne, you should continue on. I think what you were saying was important about the fact these people actually have businesses, so they're not covered.
Yes, people that have their business licenses other than professional licenses, and if they have their own location, providing services like hairstyling, estheticians, marketing professionals, they won't be covered. Also, professions like graphic designers, grant writers, fine artists are specifically exempt from this law.
And those professions that Anne, one of the lawyers who works for me, is talking about, those are generally the same people who are referred to as being exempt, which means that you don't have to pay them overtime, you don't have to do meal breaks and rest breaks. And so I think there's some public policies behind this new law that got passed this week in California. You may have heard of AB 5. One of the public policies is that very low-wage workers who really don't have a business really do need to be covered by workers' compensation and unemployment insurance if they're fired or they have an accident at work. And I think real estate is a good example. We all know that real estate agents may have a couple listings. And how it works is if you're just an agent and you're not a broker, you hang your license with your broker over at the broker's room there. And, you have that one house or two houses or three houses you might be selling. And I think that the legislature and the governor didn't want to start saying, well, because someone has hanging their license at a real estate company, they should start being considered an employee because they might only spend a couple hours with the listing. They might not sell the house. So there's some reasons why there's coverage and non-coverage in this law. Anne and I are working on a case in the gig economy, and we would like to talk a little bit about that. This person, if you look at his pay stubs, might be getting paid a couple dollars an hour, and there's some funny surcharges the company charges on his pay stubs. And can you give us a little information about how this gig economy worker is being taxed by his employer and not getting paid much?
Certainly, the income, what is paid is coming from just the tips, but the rest of the stuff he's billed is equipment lease fees, administrative fees, occupational accident insurance premium, and some marketing fees, which he didn't basically
get any benefit of.
That's true. And he didn't use them.
So how much does this guy who's making deliveries, it's not going to say it's for Postmates, it's not maybe for a company you've heard of, but it's a food delivery situation. Are there times when the guy is making very little money per hour?
Most of the time, he makes $1 or $2 less than the minimum wage.
On top of that, he is driving and he's being taxed by the employer, and he's not getting reimbursed for mileage when he's driving. And some time ago, Anna actually had a case, and she's the one that did the appeal where the person wasn't getting paid mileage when they were driving. If you do have a real employment case, I'd like you to reach out to us at 877-525-0700. Besides unpaid wages, we also handle termination cases. If you have a case where you were not paid appropriately for contract commissions, anything like that, 877-525-0700, their normal business hours. In 1 minute, Anne, can you give us a little information about that appeal that you had where the person wasn't paid?
Yes, he was a minimum wage earner. He was a building maintenance person, and the employer had several buildings. So all he did all day was to install and fix things from one and drive from one building to another. Obviously, his minimum wage didn't even cover his gas, let alone maintenance of the truck. And the appeals court judges were very frustrated that a minimum wage worker driving this truck was not paid for his mileage and expenses.
And that's a published opinion that you can read about. We get involved in workplace issues for employees, and we're usually the first to be involved in that issue with the Employment Lawyers Group. And so if there's no case that has been decided on that issue, that may be ours to be decided. Now, I'm excited that we have a guest in the studio, and we'll hear from her when we come back, this gig economy worker on the Karl Gerber Workplace Lawyer Show on Talk Radio 790 KABC. Hope you're listening on YouTube on the Karl Gerber with a K channel, maybe catching up on old episodes. We'll be back in just a minute.
That sets one apart from employment at will principles the law imparts. The common law exception for doing something good is what I'll need to overturn your